Majority of my talk is on living documents because we've just covered the three: financial power of attorney, healthcare power of attorney, healthcare directive. Those are the documents that protect you while you are alive if anything happens to you during your adulthood. Those are, in my opinion, the most important documents you can have, and I would say that an elder law attorney is going to better serve you in making sure that those documents are robust, because as an elder law attorney, what we deal with is aging, incapacity, long-term care, Medicaid, how do you pay for care? So all of those things are always on my mind when I'm saying, how are we gonna help this client? So you'll have more robust documents with, if you're being served by an elder law attorney. Oh, and one of the things that I also wanna say is that, lots of lawyers will provide wills, and we're gonna talk about the different kinds of wills and what protections are in them. But when you're going to somebody who's drafting your estate plan, ask them questions like, if I get Alzheimer's, or if my spouse does, or a stroke, or something happens, how are you gonna help me? How are these documents gonna help me? How is this plan helping me? They should be able to articulate plainly and clearly to you how they're gonna be there to help you. You can even go to the question, and what if I need expensive long-term care? How are you gonna help me so that I don't go broke paying for my care or my spouse's care? They should have a good answer for you, which is, through these documents, that we would be able to do a Medicaid strategy. A lot of lawyers don't touch Medicaid because it is a very specialized area of law. So just like everybody, you don't want to be a generalist, you want to be a specialist, right? Any of these doctors that are talking, the orthopedists, you're going to go to the orthopedist for your rotator cuff surgery, not to your family practitioner. So ask the questions. Will you be here? Will the law firm be here for me throughout the end of my life? Or will my family be able to come to you? And will you be able to help us with whatever situation arises? And frankly, our law firm doesn't help everybody with everything arises. If it's an elder abuse case, or a litigation matter, or a family dispute, we're not gonna be able to say, oh, we can handle that in-house, but we will help guide you to the right person. But if you need long-term care, or somebody in your family does, and you wanna know, how do I get Medicaid benefits, we're there for you. That's all part of what we've already thought about when we did your estate plan. So that's a distinction that elder law has from estate planning. All right, will. Now we're moving to the documents. The second category of documents are what happens when I die. A will has no effect until I die. A will says where your assets go when you die. Now, most people want to say, well, when I die, I want my spouse to get everything and I want it to be really simple. Okay. But I want you to be aware that a will can protect assets for those who inherit from you. So here's a situation. What if my spouse had Alzheimer's? I don't want him to inherit from me outright. He can't manage the money, and plus, if he's got Alzheimer's, he's likely going to go into memory care. And so I want to protect those assets for him, for his benefit. So oftentimes people say, I just want a simple will. I know what they're saying, I just want to simplify my life, and it's already too complicated, and don't make it any more complicated for me. But it's my obligation to say, all right, but let's talk about your situation. If your spouse has Alzheimer's, we don't want him to inherit outright. We want to protect those assets for him. A will can do that. And how we do that, and protecting assets and protecting your beneficiaries is along the same lines. We want to protect the money for my spouse. How do we do that? We're going to include in the will an asset protection supplemental needs trust. Big long word for say the type of trust that the state honors for protecting assets for your spouse. So, let me see, I'm not quite sure what my next thing is. All right, so it helps you qualify for Medicaid. It doesn't have to be Medicaid though. Let me give you an example. Let's say you and your spouse own a house, and I'm gonna be really simple in my math. You've got a house that's worth $500,000, and you've got $500,000 in investments, IRAs, bank accounts. So you and your spouse have $1 million. Sounds like a lot of money, right? Not if you have long-term care costs, and that's gonna go away at $150,000 a year. That money is gonna go away. So, under the situation where the couple has $1 million, half of it's in a house, half of it is in liquid assets, one of the spouses has Alzheimer's. Oh, and by the way, get the estate planning documents in place before that cognitive decline has progressed so far that you can't sign documents. All that we're talking about getting estate planning in place is you've got to do it while you still have the cognition to do so. Once that's gone, you're under the state's plan, not your own plan. So, back to my example. The husband has Alzheimer's. Let's have the wife die first. She's the one that's really concerned because she knows her husband can't take care of herself. Alzheimer's or not, no, I'm kidding, joking. So the wife dies. What is gonna happen next? Well, usually once she dies, and she's been taking care of her husband at home, he's not gonna be able to stay there any longer. It's very hard for an Alzheimer's patient to live on their own in a house. So she dies. The $500,000, her half of the estate, is going to go into a trust created by her will for her husband's benefit. All the money in that trust is not considered his money. If it was outright, without a trust, it would be. But we're putting it into this trust, this asset protection trust that her will creates for him. And that means that Medicaid isn't going to count that money as his. It's not, he doesn't own it. A trustee is somebody who is not him, is in charge, but it is for his benefit. He doesn't own it. This money in this trust doesn't count against him for Medicaid. Remember, Medicaid has strict financial standards. It's not going to count as his. So $500,000 goes into this trust. The house is $500,000. The state allows you to have a house and go on Medicaid. So this gentleman can go on Medicaid after his wife dies, pay for his care, and he didn't have to spend down any money. What he has is a house that's worth $500,000, a trust that benefits him that has $500,000 on it, and he's eligible for Medicaid. So, this usually is an eye-opener. People say, I can protect money, my spouse doesn't have to spend down everything. That's right. But maybe you're saying, I don't want my spouse to go on Medicaid. He needs to go to this memory care facility. It's got a 2-year private pay. Great. Don't jeopardize his quality of care. Use that money. Well, actually, if he's going to move to a care facility, he's probably going to sell the house. So sell the house, use the proceeds, privately pay at the care facility for however long, and then he can go on Medicaid at the same care facility and still have $500,000 in trust. So, questions, because usually people say, that doesn't make any sense to me. I thought Medicaid had a 5-year look back. Not when it comes to wills. No look back with wills. How do you protect your spouse? You have a will with an asset protection trust in it. Doesn't have to be just for your spouse. This could be for anybody. You might have a child who is on government benefits or has lifestyle issues. There's all sorts of reasons you might not want your beneficiary to inherit outright. You might want to protect the money for them. I think I already covered that. Yes, sir?
So you have $500,000 in a trust for that person's benefit. How does that money benefit that person?
Well, let's say, and let's change my example a little bit. And let's say that, the house wasn't worth so much money or something. All that money in the trust can be used for the beneficiary. It's for their sole benefit. So anything in the trust can be used for and is to be used for that person who needs care. So let's say that they need to dip into that money to pay for 2 years of private pay. Okay, use that money. It's not gonna go through the 500,000. There's still gonna be money left for that person, and they're on Medicaid. Then what do you need that money for? You know, once you're on Medicaid, you get to keep like 70 some dollars per month for haircuts and stuff. Medicaid pays for everything else. Maybe use that money for somebody to come and sit with them and read to them, or there's all sorts of ways that money can help provide better care. But Medicaid will be paying the majority of the costs.